Thanks, Sam, and welcome everyone. This is certainly a topic that has come to the forefront recently, and some of that has to do with the guidance that has been coming out on elder fraud, and certainly the Consumer Financial Protection Bureau, who has issued pamphlets regarding caregivers and fiduciaries. And I think anyone that works in the financial institution industry has certainly experienced being around account holders who you're thinking maybe this person is being taken advantage of, and yet kind of a feeling of helplessness in some cases, and how far should we go, and what should we do, and what's right and what's wrong. And so today I thought we'd kind of crack open that conversation and certainly give you some information that's out there on the Consumer Financial Protection Bureau's website, talk about some of the tips that have been put out about elder fraud, and then just some of the in-house things that come up, like can you transfer electronically from one type of account to another type of account. And some of this there's clear-cut answers for, and some of this is bank procedure or credit union procedure and your risk, what you're willing to take on. But I do think there's some do's and don'ts, and we certainly can together work through those today. So for our purposes, I thought we'd start off with what is a fiduciary, and what do we mean when we use the word fiduciary, or what is a fiduciary relationship. But typically we're talking about here when someone is named to manage money or property for someone else. The fiduciary should act to benefit the owner and not him or herself, which gets to be part of the problem. I think that's where the gist of the problem is understanding what that means. It doesn't mean it's your money. It means you're acting on behalf of someone else. And so when the Consumer Financial Protection Bureau issued these 4 pamphlets that came out in October, and you certainly can go to their website, and it's called Managing Someone Else's Money, and you can order paper copies of these for your branches, which might be very helpful. But sometimes I'm not sure that a power of attorney or a custodian or a Social Security representative payee really understands what their job entails. But they give us a couple of good, especially in the overview, a couple of good tips that can help us help our account holders in acting properly in their jobs, which is that a fiduciary or a caregiver is supposed to act in the person's best interests. So that doesn't mean that they are to benefit themselves or to lend money to other people or to get into conflicts or actions that pose conflicts. They're supposed to manage the money carefully, paying bills on time, protecting unspent funds, investing carefully, to keep money and property separate from their own. So again, this third responsibility is to keep the money and property separate from the fiduciary's own. So if the fiduciary is writing themselves a check and depositing it in their own account, or if the fiduciary is withdrawing cash and depositing in their own account, those are the kind of activities that probably could get them and you into some liability here, depending on the type of account that it is. So I was talking to a banker the other day, and she was telling me about how a power of attorney came in, took $17,000 out of his mom's account, took it over to safe deposit box area, then comes back a couple hours later, goes back to the safe deposit box area, pulls out this, I'm assuming that they pull it out. You're not supposed to know what they're doing in there. But they come back and deposit $17,000. So she was worried about how to fill out the CTR, because he deposited it back into his own personal account. And I'm thinking, here's a suspicious activity report. You better call BSA, because, again, this is about, you could be potential elder fraud, and that's one of the categories now on your suspicious activity reports. So, and to maintain good records, and that they shouldn't have joint accounts and so forth. So that's all real helpful. And as we go through each one of these that we have set up, we'll talk about this, these pamphlets that the CFPB has put out, just as well as some other do's and don'ts that are probably just good general rules for us all to think about and live by when we're dealing with these high-level accounts. So again, when we're talking about fiduciaries, one person acting on behalf of another, we see things like authorized signers, agents, in-house power of attorneys, convenience signers, they're called. These are usually created on the signature card, and typically what the signature card says is that they can make transactions for the owner, which to me means an in or an out, a deposit or withdrawal transaction. So typically we only see these on transaction accounts, like checking accounts, where money's going in and money's coming out. Power of attorney is an outside document. Some states are very specific about what the power of attorney says and when you have to take it or not take it. We'll talk a little bit more about that. That's usually set up by an outside contract. Custodians are set up under the Uniform Transfer to Minors Act on the signature card through state law. And then Social Security rep payee and veterans accounts, they're usually authorized through a letter that's coming from Social Security. It used to be the check. We used to get checks. And now you don't see checks too much anymore. Those are coming in ACH. And then what we call executors or administrators in some states, and some states now using more gender non-specific language like personal representatives, you'll see, and also that's authorized by the court. Guardians, conservators by the court, and trustees, of course, by the contract. And just some kind of simple rules that I kind of live by. It keeps people out of trouble. But typically we don't put pay on deaths or in trust fors on accounts 3 through 7 on that list. No authorized signers or power of attorneys. You don't put authorized signers or power of attorneys on, say, an estate account or a trust account unless the trust says so and the power of attorney says so. And then, again, just kind of being careful about your ownership boxes and how you set these up, and then how they sign, which I want to talk about a little bit, particularly the Uniform Commercial Code helps us a little bit there, where they talk about what is a fiduciary and, when we're put on notice that the checks are made payable to something that would involve a fiduciary. So I always like the job title, signed. Who are they acting for? Who are they? And what is their job is sort of my kind of rules of thumb on this. And again, are they sometimes going to sign without signing all that? Yes. But is it better if they do? And the answer is always yes. So, again, trying to indebt the person they're acting for and not themselves on the back of a check or an account or so forth. Because, again, they're acting on behalf of someone else in a legal capacity. So I thought we'd start off with the hardest of them all. And the hardest of them all are the power of attorneys. The litigation around the country has been significant. And certainly each state law is a little bit different. If you ever get a chance to go to the Get Technical Inc. website under Resource tab, there's a bunch of free stuff there. And what's free there is a chart with all 50 state links over to power of attorney statutes, because you definitely need to look at your statute on the power of attorney documents and the attorney in fact. They vary quite a bit from state to state on what they can do and what they can't do. I mean, it can be something really simple like what does banking transactions mean in your state? Very often in the state statutes they'll go through. And so if you called me and said, what's a banking transaction? Is an IRA a banking transaction? Well, your statute might say it is IRAs are banking transactions, but another state statute might say that they are retirement plan transactions. So each power of attorney statute is a little bit different from state to state, and they get very, very detailed in a lot of states about what this document enables the person to do and not do, and you'll see a lot of variety from that around the country. But we do know the power of attorney is the document, and it is a written authorization. And the person acting on behalf of is the attorney in fact or agent. And then the person giving the power is usually called a principal, a grantor, or a donor. But I know kind of in slang language we'll always say POA kind of to mean the person.